Good morning. Happy Friday. So let me start off with I was wrong. I was under the impression that uh, Long Island Audit's Sean Paul Reyes lost from a motion to dismiss. I remember seeing a motion to dismiss. There was, in fact, a motion to dismiss filed, but apparently there was an intervening motion that I missed. It was on my Discord. I guess, whatever reason, I just never saw it or whatever. But there was a motion to essentially adjudicate standing, which ties into one of the elements they pled in their motion to dismiss. So interesting. It wasn't a very good motion for the evidentiary hearing to determine standing. The arguments for Long Island Audit's lacking standing, I didn't think were that great. And it wasn't particularly well written because it was drawing a distinction between Long Island Audits and that the damages that Reyes was asking for were actually Long Island Audit's damages. And at the same time, in the same document, in the same motion, they say that Reyes, not Long Island Audits, celebrated an increase in subscribers after this particular issue with the mayor. Which is inconsistent. And so it wasn't a very good motion. But I'll be very interested to see. I mean, I can see how a court could grant the motion if everything that the defendant's counsel said was true. But I could also see a skilled attorney going in there and making an excellent argument for why Reyes is the proper plaintiff. Because I would argue that Reyes is the sole face of Long Island Audits, and Reyes is the true entity there. Long Island Audits is essentially just an alter ego for him, because he posts on all of his social media as Long Island Audits. They're basically inseparable. And it was his face and ultimately his damages, because he's the sole owner of Long Island Audits, blah, blah, blah. I could see him crafting an argument. I don't know all the facts, so I'm just like spitballing here, just pulling shit out of my ass. But I could see a skilled attorney crafting an argument that could persuade a judge that, in fact, Reyes was the proper plaintiff. Especially with defense conceding that Reyes, not Long Island Audits, was getting an increase in subscribers. If they're Reyes' subscribers, then Reyes, you know what I'm saying? Like, it's not Long Island Audits at that point. Now, I'm sure they would backtrack and clarify, but if I was representing Reyes, which I'm obviously not, I'm not licensed to practice in Florida, and I don't think he likes me very much, which I don't understand why, considering my charming personality. I guess I did say that he was essentially retarded, but I say it in a loving way. Anyway, hi, buddy. It'd be interesting. So if someone gets a transcript from the hearing or a copy of a statement of decision, I would love to see it so that I could understand how everything went so terribly wrong at that hearing. That being said, they still had a pending motion to dismiss, which, even if he was the proper plaintiff, Long Island Audits or Reyes, whichever way that hearing on standing turned out, he would still have lost. I mean, he might have survived the hearing on standing, but the motion to dismiss, I mean, there's just the correlation between that one case that I brought up that I forget the name of now because it's a Florida case and it's not really relevant to me, where the mayor had a blog and the police chief sued him over statements he made on the blog, but it was the mayor's blog, like mayor of such and such town or city or whatever. And the court said no. I mean, yeah, so the correlation was just too strong between the two cases. The fact patterns were almost identical in the substantive, like the relevant facts were almost identical. So it's just still just a loser, just absolutely loser. So he was going to lose regardless of whether he won, but a good attorney could have got him past standing, I think. Pretty sure. I mean, I'd have to see the transcripts and the statement of decision to be sure, but I think he could have. In other news, I saw that, what's his stupid ass name? Stout, and Stout. Stout, and Stout. Pro se litigants got a, looks like a small claims court win. $4,000 default judgment against Attorney Shield or whatever they called that. I guess a lot of the big pro auditor channels were pushing for this Attorney Shield thing where, like, if you get into trouble, you can just call up an attorney and you know, they can give you advice right there on the spot. And what are those guys, the Pot Brothers or the Pot Attorneys or whatever they are? I mean, like, literally they gave you all the advice you need. Shut the fuck up. Just shut the fuck up. Don't talk to the cops. If you're in trouble, shut the fuck up. You know, if you think you may have broken a law, shut the fuck up. If you're not the complaining victim, shut the fuck up. You know what I'm saying? Like, that is the advice. That is all the advice in it. Like, if my client called me and said, you know, hey, the police are at my door, what should I do? I'd be like, shut the fuck up. I don't need to talk to the cops. I need you to shut the fuck up. There's no way I'm going to talk the cops out of investigating you. You need to shut the fuck up. And then come to my office when you're done with them so we could talk and figure out what the hell's going on and maybe take some proactive steps. But in the meantime, shut the fuck up. That's attorney advice for you. That is the sum total of any interaction with the police where you may be a suspect. Where there's any remote possibility you're a suspect, shut the fuck up. So it's a really stupid program anyway, and I personally don't understand how, as an attorney, I could give someone better advice, because, like, you don't know what the cops know. If I'm working on a criminal case, which I do rarely, but I do occasionally, I have the benefit of the police reports. I have the benefit of a complaint against my client, you know, State of California versus so-and-so. I know what's going on. I have a basic understanding of what's going on. I can get my client's version of it. But you'll find that, I mean, for those of you who are attorneys out there, you'll know this. You'll find you get a different version from your guy almost inevitably, almost invariably, than what's in the police report and what's shown on the body cams. And that's not saying that your client is lying. And, you know, everybody has their own perspective on things. Everybody filters things through their head. And, you know, most people are biased in favor of themselves. And, you know, everybody sees things a little differently. But I don't know, like, if there would be enough time in a police interaction for me to actually drill down to what the actual core of it is, get a good understanding of it. So, I mean, if they hired me, and they haven't reached out to me, I'm not saying that they have or anything like that, but, like, if they hired me to be one of their attorneys, you know, ring, 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 yeah, this is John from Attorney Shield. Hey, I'm in this situation. Yeah, shut the fuck up, call a local attorney, and talk to that local attorney, because there's going to be way too much information for me, and I'm not going to be able to talk the cops out of doing whatever they want to do. So, shut the fuck up. If you do get arrested, ask for an attorney and shut the fuck up. It's a dumb idea. But anyway, it's a real bad look on them. Apparently, the story that I'm being told, I haven't verified any of it. I've seen the Virginia screenshot from the court record showing that he got the $4,000 judgment. So great. Congratulations to you, Stout. Next step, all you have to do is collect it, because just because there's judgment doesn't mean they're going to write you a check. But anyway, it's a real strange situation because apparently, allegedly, Attorney Shield got served, somehow filed a motion to change venue or maybe forum nonconvenience or something. I don't know exactly what the motion was. I'm told it was a motion to change venue. I'm not sure why they would try to change venue in Virginia to a different spot in Virginia. I mean, I did a quick search and they don't appear to be registered as a corporation in Virginia. So I don't know that it was proper for them to be sued in Virginia. Generally speaking, the defendant has the right to be sued where they live or where their principal place of business, their headquarters is. But I'm told it was a motion to change venue. So let's just go with that. Apparently, they then didn't show up to the motion to change venue. They must not have filed an answer. And so then Stout got a default. How bad is that? If in handling your own affairs, you don't deal with situations, legal situations, and yet you are going to give legal advice to people in much more serious situations. I mean, are you going to show the same level of care and concern and follow through with them as you would with your own lawsuit, or what? Not a good product advertisement for them. I'm surprised they let this go, but I'm also surprised they're in business. I mean, I really don't understand what they think they're going to provide to people or what people think they're going to get from this service. Because again, like, just because you have an attorney on the phone, like people's first reaction was, I'm going to call my attorney. But like, there's not a lot the attorney could do for you. The attorney's work is done around court, not around the initial arrest. Other than give you the advice of shutting the fuck up. And if you do get arrested, ask for an attorney. Yeah, it just doesn't make sense. But again, congratulations to you, Mark Stout of Stout, and Stout Pro Se Litigators. Your ability to get a default judgment secures your role as a preeminent litigator. Anyway, thanks for watching and have a great weekend.